Good afternoon and welcome to episode number 19 of At Your Service with Haber and Martinez. Each week is another episode, and each week it's hard for me to believe that we've actually been doing it this long. Welcome again. I'm Mike Haber, and next to me is my co host, Ed Martinez. And today we're going to talk to you a little bit about probation. At least that's our topic. Hopefully we'll stick to it, but with us you never know. We are like the kings of tangent. If tangent were a country, we would be the kings, co-kings.
Listen, I
Uh,
only go where I'm led. So where the conversation leads me, that's where I go, man.
no, you're no follower, Martinez. You're no follower. So probation. I've entitled this episode "Probation: Palpability, Practicality, Pitfalls, and Pro Tips." We talked a little bit last week. In fact, our whole show last week was dedicated to what we called collateral consequences of criminal cases. And one of those very reasonably foreseeable collateral consequences is probation. So today we want to talk to you a little bit about what probation is, different types of probation, because there's a variety of different forms that it comes in, conditions of probation, some of which are absolute mandatory for everybody who's on probation throughout the state, some of which can be custom tailored or structured to a particular defendant or particular case at hand. We want to talk to you about violations of probation, the nature of those things, how do they work, the functionality, the protocol, the timing, how they function, enforcement, modification, early termination, and finally, we'll give you what we call our pro tip segment, which is what we're particularly proud of. And that's basically going to be surviving probation, right? What's the
Yeah.
best way to get through it? What gives you your best odds at success? And how are you most likely to wind up being successfully terminated as opposed to VOPed and incarcerated? So
Well,
with that,
before we get started, I have a question.
sure.
I got a new haircut, and I'm starting to feel like I look like I came right out of central casting for Shawshank. Like, is it me, or do I look like they wanted to cast me in a 1920s gangster movie?
I don't know, Ed. Far be it from me to comment on your
Well,
looks. Given
I don't
my
know.
own, given my own shortcomings, I try not to attack anybody on theirs,
You
especially
you
hair. There's a subject I'm not allowed to chime in on at all.
you look. I don't. I mean, I've been meaning to tell you this for a while, but with that untrimmed beard, you look like you're going to do the remake of Castaway. That's all I'm
Yeah,
saying.
well, guess what? It's almost Christmas, bro. Christmas is
Oh,
not
that's
canceled.
right.
I don't care. I don't care what anybody says.
You do the whole. You started growing your beard already for the whole Santa
I
thing.
don't.
I had no
I don't
idea.
know if there's actually going to be a Santa thing this year because of COVID again. But
You
I got to
like
be. Listen, Ed. Preparation, preparation, preparation. Right, the most important things in life. Beards like this don't grow overnight.
and here's a pro tip before we get started. If you're ever in a situation where the cops are questioning you, you don't talk. For example, I was just about to say, let's be honest, Mike. You do this whole thing because you like to get some of those soccer moms sitting on your lap. See, no answer.
No
That's how
answer.
you do it.
I, I have no idea
No
what you're talking
response.
about, Senator. I'm not even going to go with the fifth. I'll just go with the congressional. I'm sorry, Senator. I can neither deny nor confirm that statement.
Yep. Or the
But
Ronald
let's get
Reagan. I don't remember.
let's get back. As far as probation goes, probation is what we call an alternative to incarceration. Okay, it is a option that the court has in lieu of if you are found guilty of any criminal offense. There are circumstances where, in lieu of incarceration, being locked up, being sent to jail, or being sent to prison, you can be supervised in your own community. And it's what we call actually community based supervision, it's community based sanction.
Correct.
And probation runs a gamut from very little supervision to an incredible amount of supervision. But the object of it, no matter what, is to keep you out of a jail cell. In other words, allow you to not unnecessarily take up taxpayer funds, lay around in a dorm room or in a cage without being productive or accomplishing anything. And there are many compelling reasons, and some not so compelling, I suppose, for people to be placed on probation. But be that as it may, again, we run this gamut. So the least restrictive form of probation is what we call administrative or write-in probation. And that's where, during whatever period of time that the judge assigns for you, you have to check in with your probation officer once a month, usually by telephone or by email. You don't even have to show up in person. This happens a lot when we have out-of-state probationers. I think I mentioned the little joke phrase that we have in our industry, came on vacation, left on probation. Well, that actually happens very, very regularly. We are a transient state. We are a tourist town. And so we have a lot of people that come through, spend a little time, and, for one reason or another, wind up entangled in the system, and then they wind up leaving on probation. So,
but it's mainly reserved for people that really there wasn't a major crime. It wasn't that serious, wasn't that bad. Because you can also have your probation transferred to your home state or county.
well,
So
that's a
we
lot more
can do that too.
difficult. That's a lot more difficult under certain circumstances, and there are some
Right.
cases where you cannot do that at all. Some charges are disqualified from transfer.
Right.
But that gets into the interstate compact, and that's a whole different subject for another day. But another corollary to what you just said is administrative probation is also oftentimes used as what we call a step down. So somebody who has successfully served a good portion of their regular probation or a more restrictive form of probation, which we'll talk about in a moment, can sometimes be stepped down to this administrative form of probation. So, if you're a good boy and a good boy or a good girl, or both, during the course of your probationary period, you might be able to petition your judge and say, Judge, I'd really like a little more liberty. Can I please convert to administrative or non-reporting probation?
And as a early pro tip, that usually works best when you've been really good and your probation officer and you get along, and the probation officer will help by saying either they don't object to it, or sometimes they even they recommend it. I've had probation officers, right, Mike, where I call them up and I say, I'm thinking of doing this, and they say, yeah, absolutely, I recommend it. He's a good parolee or probationee. Calls me, comes in, he's never tested positive, been doing it for a while, 6 months, maybe a year, and we step it down. And that, of course, Michael, correct me if I'm wrong, that's if we can't early terminate, which I know you want to get to.
Well, let's get into that a little bit later. And of course, your relationship with your probation officer, we're going to talk a great deal about. And that's significant. But let's keep rolling on these different forms of probation. So the most restrictive, if we go to the other end, is what we call community control. Right. Community control is commonly known as house arrest.
Right.
It's not really the same thing, because house arrest is actually a term that's used for a bond status, right? Somebody who's out on bond, who's locked down at home, in lieu of being pretrial detained, is actually on house arrest. But if it's a community-based sanction, if it's a what we would call super probation, it's community control, and that is house arrest, lockdown in your home. And that can be as restrictive as 24/7, you are not to leave the house. Or it could have any conceivable possibilities for you to be able to leave. For example, you may have time carved out to work, or to go to school, or to provide transportation for children or elderly or disabled relatives. Any of a number of reasons you may be able to be allowed out of the house for a certain amount of time or restricted to a certain location. The bottom line is it's much more restrictive than regular probation, because you don't have freedom of movement as you would on normal probation.
The way I heard a judge explain it when I was a young prosecutor, and I've said it to all my clients since, you are exchanging the four walls of your prison for the four walls of your home.
Exactly.
Make no mistake about it. You're in prison.
There's no better way to describe that. You just gave it the absolute best.
The only difference in this, instead of being able to go to the yard to do some exercise when they tell you, or go to the bathroom when they tell you, you're allowed to go to the bathroom when you want. You're allowed to go into your backyard if you want. But as far as going outside of that, you have to get a specific order from the judge. So like Michael said, they'll say you can go to work, and they give you specific times. They're not going to just let you go to work. You have to know what your time is, and they'll give you travel time. So let's say you start at 9 and you finish at 5. The judge will typically say, okay, I'm going to give you from 8 to 6. You got to be back in your home jail by 6. And if you screw up even a little bit, you go right back. So there's a benefit. You get to watch TV, right? You get to be home with your family. If you're married, you get to have basically conjugal visits, but don't screw around, because they'll put you right back in jail.
I always like to describe it in the light of Whether we're talking about probation, community control, or even if it's a bond situation or what have you, I like to say that it's nice for the client to have the option of going to bed when he or she chooses with the company or no company of his or her choice, and then waking up the same way with the company or no company of his or her choosing.
Because let's be honest, a lot of our clients that are on house arrest were put on house arrest because of the company that they were keeping.
Could
So it
be.
might be better to just stay away from them.
So apart from those two polar extremes of non-reporting and community control, we have straight up probation. And straight up probation also has its own little spectrum, because you can be regular reporting probation, which we're going to talk about next, the standard conditions that everybody in the state of Florida is subject to. Or you could be more extreme reporting probation that's still not as extreme as community control. And there are three specific categories. The first would be, above regular reporting probation, would be regular reporting probation with special conditions, whatever those might be. And we're going to talk about them in a minute too. And then the next two step ups from that would be what are specifically designated as drug offender probation and sex offender probation. And the reason that they're carved out and treated differently are because drug offenders and sex offenders are both given specific treatment protocols as a condition of the probation, which is what makes it different than regular reporting probation. And it's not necessarily special conditions, because anybody who goes into drug offender probation or sex offender probation has to meet all of the special conditions, all of the conditions of regular probation, plus all of the extra conditions of either their sex or drug offender probation. And they still may be subject to additional special conditions depending upon the judge and that particular case.
And,
So,
and let's make no mistake about it. Both of those probations are not easy. They may sound easy, and you get a huge benefit from them. I don't know if you want to talk about this later, Michael, but for example, on drug offender probation, you're going to get a benefit from it, either a dismissal of your case because it was a simple drug case, or maybe a withhold where you really should have been going to jail or prison, but they know that you're addicted. And just so we're clear, for example, on drug offender probation, you're not allowed to be on that type of probation or in the program if you had anything to do with selling or possessing drugs in an amount that they consider was for sale. They don't like that. They want only people that are addicts in there. And they give you some leeway till you get better, but it's hard. You're not allowed to even smoke cigarettes. They don't want you doing anything that's addictive. So you may think, well, I'll go into drug offender probation because I'm addicted to coke, but I can still smoke cigarettes. Nope. Oh, I can still drink. Nope. You can't do anything because they want to make sure that you break your addictive traits. So it's hard. It's really hard.
let's talk about regular probation and the standard conditions. I just want to take a moment, and I'm actually going to read down the list. Anybody who's interested can Google Florida Statute 948.03. That's 948.03, and that contains the standard conditions of probation, of which there are 15. These are 15 things that anybody and everybody who is placed on probation in the state of Florida is expected to live up to.
You have to follow. You have to follow.
No alternative.
You cannot break these rules, no matter what the charge is, no matter the length of your probation, no matter your judge, no matter your lawyer. And these are things you cannot violate.
The reason for that is because the first sentence in this statute says the court shall determine the conditions. So there's no question that it must be done. These conditions, the statute goes on to say, conditions specified in this section do not require oral pronouncement and may be considered standard. So whether the judge tells you or not, which they generally don't. Judges don't usually sit there and chime out what it is that you are obligated to do as a routine condition of probation. Instead, they direct you to the in-court probation officer, or they tell you to report to the department, and then they turn around and it is probation that instructs you on these standard as well as any special conditions. Although if the judge is going to issue any special condition, that is anything other than these standard 15, they have to do it on the record and they have to tell you in open court. It's got to be part of the disposition. But let's run through these 15. You must report to the probation officer as directed. You must permit a probation officer to visit you at your home or elsewhere. You must work faithfully at suitable employment insofar as may be possible. You must remain within a specified place. You must live without violating any law. You must make reparation or restitution if ordered. You must. I'm trying to.
I don't know, but that's so far.
You must
So far,
pay.
it sounds like the list that my second wife had for me before we got married. That's all. I'm just saying.
You must pay for any medical care, treatment, hospitalization, or transportation that you incurred while in detention. You must support your legal dependents to the best of your ability. You must make payment of any debts due or owing to the state, meaning fines or court costs, things like that. You must pay any application fees or attorney's fees and costs. That's not private attorney's fees. The judge isn't going to order you to do that, but you may have a public defender fee that you're obligated to pay. You are not permitted to associate with persons who are engaged in criminal activities. You must submit to random testing as directed by your probation officer. You are prohibited from possessing, carrying, or owning any firearm or weapon. You are prohibited from using intoxicants to excess or possessing any drugs or narcotics which are not prescribed. You are to submit to a blood draw or any other biological specimen like a cheek swab if necessary. You must submit to taking of digitized photographs for records. Those are the absolute requirements. And some of them are not as plain as they may sound, right? So, for example, the one that says you must permit a probation officer to visit you at your home or elsewhere or whatever, basically what that means, it doesn't say it, but what the courts have interpreted it as meaning is you have no Fourth Amendment right when you're on probation. No. You cannot deny access to your probation officer, nor do you have any right to demand that they produce a warrant. You can't tell them to come back later. You can't not answer the door. I mean, you can do all of these things, but if you do, you're going to get violated for each and every one of them.
Even law enforcement.
So
law enforcement can show up at your house and you got to let them in.
The one where I mentioned you can't commit any new crimes, okay? There's an interesting one because this is a very should be common sense, right? The first rule of probation is don't violate probation, right? It's like the first rule of Fight Club.
Exactly.
Don't violate probation. So there are two different types of, well, I don't want to get into probation violations just yet, but let's just say one of the most common ways for probation violation to occur is for somebody to get arrested for a new offense while they're on probation. And it's a very common misconception that people have that if they get arrested and that new charge gets dropped, they can't be violated. And that couldn't be further from the truth, because that provision that says do not commit any law violations does not mean do not get convicted for committing a new crime. It means don't get arrested. It means don't get wrongfully arrested, don't get rightfully arrested, don't get indifferently arrested, don't get arrested, period, paragraph.
Do you want to go into now what the standard is when a judge violates you, what the standard is as far as...
No, we'll get to VOP. We're going to get to VOPs in a minute. I just want to go through special conditions first.
Gotcha.
So I just read you a list of standard conditions, 15 things that everybody is required, every probationer in Florida is required to honor. In addition to that, if the judge deems it appropriate, or as Ed and I were talking about earlier today, sometimes the defense and the prosecution will agree and stipulate to certain conditions that are above and beyond standard. Why? Well, maybe it facilitates a plea agreement, right? Maybe Ed or I are representing a guy who's double dog dead. We know we have absolutely no shot at trial. The prosecutor's holding all the cards, and worse yet, the prosecutor knows it. So they've got our client by the ball sack, and all they need to do is squeeze. But we come to them and say, listen, don't squeeze, let's massage, okay? And here's what we'd like to propose. Consider these types of additional restrictions in lieu of a jail sentence, because this is a client who deserves the break. And so it may be that we bump it up from standard probation to house arrest.
Right.
Maybe we offer community control. Maybe we offer psychological treatment or counseling or classes or community service hours. Go ahead, Ed. You're dying
Yeah,
to say
well, I
something.
was going to say sometimes it's not even because our client is a nice guy or deserves a break. For example, um, I think Michael and I are both pretty good at trying to read the room. So when I'm talking to a prosecutor for, let's say he gets a charge that involves a firearm, and what the prosecutor is really, really pissed off about is the firearm, not so much the charge. If there wasn't a firearm involved, this would have been a probation plea. So I'll say to him, even though he's still getting a withhold, right? Because if he's not a convicted felon, he would be able to get that firearm returned to him unless it was stolen. I may say, look, how about you give him a withhold, but he'll surrender the firearm. He'll get rid of it, even though he's
Or
entitled
on
to
the
have it
other
back.
hand, he could just
He's not going
on
to
the
take
other
it
hand,
back.
he could transfer title of the firearm to his lawyer.
Well, that's another issue altogether. But the point is that, yes, because I do that often. But the point is, I realize what it is that really this prosecutor is concerned about is, a road rage incident, let's say, where he had a firearm. And what he's really concerned is that tomorrow this guy's going to shoot somebody. So I'll say, look, this is the only gun he's got. He's going to surrender the firearm. Legally, he could ask for it back, but that's why you're asking for a conviction. So he can't have any more guns? Right. Well, how about this? How about he surrenders his firearms and you give him a withhold and then, another 3 years probation or something. So it all depends on, we couldn't tell you every scenario because every scenario is like a chess game. It depends on the move they make. And then Michael and I got to make our move. But those are kind of similar things, some of the things we can do.
Very, very common special conditions include things like GPS monitoring, specific classes, maybe an anti-theft class or an AIDS class or a ethics class or something
and
like
outside
that.
of the box, for example, I do this a lot for battery on law enforcement officers, right? Cops usually it's not that you hit them because sometimes you get arrested because you just pushed them. That's not a big deal, obviously. But what is it that pisses everybody off is that they feel like you disrespected them, right? Like you have no respect for authority. So many times I work these cases out by just having my client agree to write the officer a letter of apology or a 500-word essay on law enforcement.
Or a contribution to the police officer's assistance trust.
Or a contribution, right. So, and then, and again, what do? I find out, well, why is this cop so upset? All my client did was push him. I get it. He shouldn't have done that, but not like he punched him in the face or anything. And then the prosecutor told me, listen, this cop is pissed because it's a lack of respect. I'll take his depo and I'll ask him, listen, I understand you were disrespected. How would you feel if my client apologized? Well, that was should have done on the scene, or that's a good start. Okay. And I make my client write a nice letter of apology, and then we work it out. And that's going to be the condition of his probation. He's got to write that cop a letter of apology.
So that's example of a special condition. You also have community service hours, restitution, things along those lines.
Those are the standard stuff.
So when the judge announces these special conditions, when a judge places you on probation, that is the time. Here's a pro tip for you guys. That is the time that you want to make sure that any special circumstance that you have is announced and cleared up then and there. Because there's nothing worse than going back to the court later and playing catch up. You
Right.
want to do this up front. So for example, and I think somebody mentioned this on our last show, let's say that there are standard costs of supervision where you get placed on probation, that it costs you $40 a month to be on probation, or $100 a month to be on community control, or $10 a day to be on GPS monitoring, whatever it may be. If you have a financial issue, bring it up at that moment at the time of sentencing, because the judge is free to exercise his or her discretion to amend or waive those costs.
Right.
So you can say to the judge, your lawyer can say to the judge, Your Honor, my client doesn't have the ability to pay cost of supervision at this time. He's unemployed. He's just getting back on his feet. You can structure this however you want. But the point is, if you don't do it up front, that first month that your fees come due and you don't make your payment, bam, violation. So you can avoid that by dealing with it up front. Similarly, here's another example. We get this a lot. Travel. We have some clients, usually your probation will obligate you to stay within either the geographical jurisdiction of the court or the state of Florida or the Tri-County area or what have you. Make it clear if you need to travel on a regular basis. If you're a trucker, for example, make sure the judge knows that. because you don't want to have a problem where you violate your probation because you have to go to work, or you can't go to work because going to work will violate your probation. Let's say that you have special situations where you need to go to certain, maybe prohibited places. Get it out there. Make sure the judge knows. Drugs. Let's say that you're on prescription medication. You have a medical marijuana card. Before you test positive on your first urinalysis, let the judge know.
And
Judge,
hold on, Michael. I just want to add one thing, because that last thing you said, it goes even if you don't have a medical marijuana card. Suppose you snorted cocaine 2 days ago. Suppose you smoke pot and you don't have a medical marijuana. I don't care. Suppose you just shot up heroin or crystal meth, but you're taking your plea today. You did that 3 days ago. Nobody is going to do anything to you if we address it with the court now. You tell your lawyer. And honestly, we don't even need to tell the court anything. Usually, all I tell the judge is, Your Honor, just so the record is clear, my client may test positive for any controlled substance if they test him within the next 30 or 60 days. I don't need to tell him it was crystal meth. I don't need to tell him it was heroin. I don't need to tell him it was pot. All we're saying is you may test positive. The judge will enter into the order that you cannot be violated for testing positive for a controlled substance within the next 30 or 60 days.
well,
They'll
either
test
that or
you,
either
they'll
that or
test you, but
they'll
they
just
won't violate.
delay. Either that or they'll just delay your test. So,
Right.
look, a lot of times the generic rule, and again, it's generic. It's not a rule. It's not set in stone. But the general rule is whether we're talking about pretrial release or probation or diversion or virtually any court supervision, if you test dirty out of the gate the first time up, they will generally give you a sufficient amount of time commensurate with the substance that you tested for to test clean. So in other words, let's say you came up positive for cocaine. You can't be charged for possession of cocaine because you had cocaine in your system. It doesn't work that way. Right. So what a judge will generally do is say, all right, you know what? Let's give it 7 days. Come back. I want you to come right into my courtroom and drop urine in here. If you're clean, you're clean. And if not, you better bring your toothbrush because you're going right in. So,
Right.
They will generally work with you. Again, it's a respect that you're showing the court by being honest and upfront with them. And at the same time, it's self-preservation. It's Darwinistic because you're basically looking out for your own interests by proactively dealing with these things as opposed to reactively dealing with them. So
No.
I always say to people,
It's like everything. It's like everything else in life, Michael. If you know that you were at a party somewhere and somebody came up and inappropriately grabbed you or hugged you, and you're married and they took a picture, you're really better off going home to your wife that night and telling her before your wife sees that picture on Facebook or Instagram, and then you're gonna have a hell of a time explaining why you didn't say it up front. It's the same exact concept.
solid advice. Solid advice from a guy on marriage number 3. He's truly an expert.
I've learned the hard. No, I'm kidding. That's never happened to me. But seriously,
So,
on a serious note, that is really it's kind of like being in a relationship. You want to be upfront, right up out the gate. They're not going to get offended. In this jurisdiction, most judges will say, "Okay, let's not drug test him, or we won't violate the person for 30 or 60 days." Some other jurisdictions will say, "Well, then come back in 30 days, and we'll take the plea then." What's the difference? My opinion. This jurisdiction has so many cases that the judges are trying to close them out as quickly as possible to get them off their audit because they've got other cases they got to get to. You go to some of these smaller towns, some of these smaller counties, the judge doesn't have a lot of cases, so he doesn't care. He's not going to put you on probation and then let you violate. He just tells you, okay, come back in 30 days.
We're about to get on to violations of probation, but before we go there, I just want to point out one more thing. There is a significant difference between misdemeanor probation and felony probation. Depending upon where you are in the state, some of the smaller jurisdictions, it makes no difference. But here in Miami-Dade County, for example, it's different the minute that you cross the Broward border, because Broward takes a totally different approach, as do most of the other jurisdictions in the state. But here in Miami-Dade County, misdemeanor probation is contracted out to private companies. So if you're on misdemeanor probation here in Miami, you're going to be supervised by either the advocate program or court options. And those are, again, private companies that have contracted with the court system to provide misdemeanor supervision. But felony probation, no matter where you are in the state of Florida, is done through the Department of Corrections. So you actually get a DC number, a Department of Corrections number. You just don't get a letter for having been assigned to an institution. So some smaller jurisdictions do not differentiate, and they do not contract out privately. So DOC does misdemeanor probation and felony probation in many jurisdictions. And another little pitfall that we've had on this angle that I've come across multiple times in my career, and this is from a defense attorney's perspective, it is nothing shy of absolutely maddening. If I get a felony case that I beat up so badly for one reason or another that I get the prosecutor to agree to bind it down and reduce it to a misdemeanor and give my client misdemeanor probation, for whatever reasons, probably laziness, they don't want to null pros or dismiss the felony case and refile a misdemeanor case, reopen a new case, and now close it with probation. But if they did that, my client would be supervised by court options and or the advocate program, as opposed to pleading to a misdemeanor in felony court, where they're now stuck on felony probation, even though it's a misdemeanor charge.
Well, listen, I didn't know that, Michael. You and I have actually never talked about that before today. I can tell you why I did it as a prosecutor. When I was a county court prosecutor, right out of training, right out of orientation, there was a kid that was arrested for battery on a law enforcement officer, on like 4 of them, to be honest with you. And it was, there were mitigating circumstances. I'm not going to get into it. It wasn't a bad kid. It wasn't like he went after the cops and said, I'm going to kill you or anything. He was upset because his brother got into a car accident and they were carting off the scene. He wanted to know if his brother was still there and dead. And, they had the yellow ropes and they were doing a crime scene investigation. I mean, it was an accident, but they still have to do their job. And he kept trying to cross through. And when one of the cops tried to grab him, he shoved him and whatnot. So the cops felt bad for him and they said, all right, listen, we'll agree to him taking a misdemeanor battery. Right? Because they had warned him several times and he had pushed the cops and several times. And finally, like the fifth cop he pushed, they said, enough is enough. But they agreed to a misdemeanor battery. But instead of taking the plea in felony court, they did, like you said, they dismissed the felony. They refiled it as a battery misdemeanor. We went in front of Judge Ed Newman. I caught the case. I talked to the felony prosecutor. He told me everything that was going on. Case got called up. Case got called up. And you know what the defense attorney did? They said they want to go to trial, but they were not going to take a plea now.
All right, but so look, there's an easy end around for that, and that is you go on the record in felony court and you put it all on the record, period. And so the defendant actually is basically agreeing that if he does not follow through with his agreement, the felony charge is going to be reinstated.
But here's the thing, and I don't want to bore everybody with our legal jargon, but here's the thing. One is you have to be very specific. And I got to tell you honestly, Michael, my legal gut instinct is that he'd be able to back out of that offer anyway, because it's his constitutional right for him to have changed his mind before. He did all that on the record today. Next Monday, he went in county court.
Okay.
He said,
then he winds up back in felony court facing a really pissed off judge and prosecutor.
But he won't if the state dismissed it. He won't, because then double jeopardy will attach. So
there's no double jeopardy at that point.
If he dismissed the felony, yeah. If he dismissed it, I think there is. But again, let's not bore the audience.
Right,
the reason that I used to do it is because of that. And then you take the plea up there. And obviously the state attorney doesn't care because he's not going to be on felony probation. He just wants to make sure that the case is closed out.
Well, I'm going to agree to disagree. And I'm going to go with my theory that they are lazy and they simply don't want to refile the case. Okay. They just want to get it done. Right. And they figure they're giving you enough of a gift as is. So don't look a gift horse in the mouth.
That is true.
Which is a compelling argument. Just one more thing I want to mention, and this is like Haber's really bad jokes. You know what a polygon is?
Yeah.
The two-dimensional shape. When a polygon goes on probation, they give it an angle monitor. Ooh.
Yeah.
That's harsh.
That is brutal.
That's harsh.
That's not even a dad joke. I don't even know what that is.
Violations of probation. So a violation of probation is an allegation by your probation officer that you failed to live up to some obligation or you failed to honor some condition of your probation, whatever it may be. And they come in two different forms: technical violations and substantive violations. Either one of them is brutal. There's no good violation of probation. And one of the things that makes probation such a dangerous proposition for anybody is the possibility of a violation. Because when you go on to probation, apart from giving up your Fourth Amendment privileges and rights. You also are treated differently, kind of like a sub-citizen in the criminal justice system, at least for purposes of the probation violation component.
Right.
Your burden of proof is significantly lower in a probation violation hearing. You have no right to a jury trial in a probation violation hearing. You have no right to bond on a probation violation. Many of these things that people are entitled to and sometimes even take for granted in a substantive criminal prosecution simply do not apply. Hearsay is admissible in a violation of probation hearing, unlike inadmissible hearsay is not allowed. There is no such thing as inadmissible hearsay in a VOP. Anything comes in. It's a free-for-all for the
The
state.
only thing is the judge can't base the ruling only on hearsay.
Correct.
But
They
if
have
the
to
judge
have
has
something.
If the judge has one thing that's not hearsay and 10 other things that are hearsay.
It's got to be corroborated. It's just got to be corroborated. That's it.
That's it.
And then the only other limitation on a violation of probation is the court must determine that a violation was both willful and substantial. Those two prongs have to be established by the court in order for your violation to be upheld on appeal. What do we mean by willful? So let's say I'm accused of violating the condition of probation that says that I didn't make a restitution payment, or I didn't make my probation fee payments, or I didn't pay my court costs, or I failed to pay my costs of supervision. Any of those types of financial concerns are only willful if the government can prove, and by the government, even though it's the probation officer that makes the allegation, it's the prosecutor that fights the case for the government in the courtroom. The government needs to be able to establish that I had the ability to pay and that I willfully, again, the prong of willfulness, chose not to. So they have to be able to go in front of the judge with evidence, not just statements, but proof that I had the actual ability to pay and made a conscientious decision to spend my money on hookers or drugs or vacations or whatever.
Why you always got to go to hookers and drugs, man? Why you always got to go there?
It's just a natural flow.
And why you always got to look at me?
It's the nature of the business. It's the nature of our business. If we didn't have hookers and drugs, we'd be out of business. Face it. So, again, the government has to prove that I intentionally had the ability to pay, but chose not to do so. In other words,
that's hard, and that's very difficult.
Well, it may or may not be, depending upon who you are. I mean, again, I don't want to cast aspersions, but it's going to be a lot more difficult for the government to prove that against a homeless person than against, say, Robert Kraft, right? So it's, depending upon who you are, yeah, it may not be that tough to prove that type of a thing. But the other is substantial. It's got to be substantial too. So let's say that I get 200 community service hours over the course of a 1-year term of probation. And let's say I complete 196 of them, and my probation officer violates me for failing to do the last 4. I may have a pretty decent argument that even though it was willful, it wasn't substantial, right? Because I did 196 out of 200, Judge. I'm only missing 2%. Is it really all that big of a deal? So you need both willful and substantial in order to have a violation. But let's talk about the protocol. What is a VOP? So one of two things can happen. Either your probation officer can simply smack handcuffs on you and tell you that you're under arrest for a violation of probation, or they can go to the court and seek a warrant. Those are the two ways that these things happen. There is a third, and that is some probation officers will give you a heads up, and they will say to you, Haber, listen, you got 2 months left on your probation. You owe X amount of money. You didn't complete this class. You have a couple community service hours to do. I don't want to have to violate you, but I'm going to have to violate you because those are the rules. Hop on it and get to it now.
Right.
So that's the other possibility. But the normal protocol is your PO simply swears out a written affidavit. My name is Mike Haber. I'm a probation officer. I'm assigned to supervise Edward Martinez. Martinez was sentenced to XYZ on January 1st.
Good luck if you were my probation officer.
His probation end date is December 31st. It's now November 1st, and he's failed to do XYZ. That's the standard, at which point the judge reviews it. And if it states the basis of a probation violation, if probable cause exists, the judge issues a warrant, and that's it. You're now a target. If you get taken in on a probation violation, then you are not entitled to bond.
And 99 times out of 100, you're not going to get one.
Depending upon the type of probation, depending upon the probation history, depending upon the allegations, that's entirely true. And this is another pro tip. If you know this probation violation is coming at you, whatever it may be, it's time to lawyer up, because your lawyer can get in front of it. Your lawyer can get on with your PO, create a record of a conversation, reach out to the assistant state attorney, try and stave off a warrant. If not, try and broker conditions of release. There's a lot that can be done. We can put it on calendar and take it right to the judge. Going back to something I said earlier today, proactive versus reactive. The more that judges sit here and see a revolving door all day long. It's case after case after case. And unfortunately, a lot of times they see the same defendant over and over. But there's one thing that they all have in common, and that is there is a difference, at least in the mind, if not in the reality, of an individual who walks through the front door of the courtroom and is sitting in the audience waiting for her or his name to be called, than an individual who is escorted into the courtroom through the back door, handcuffed and placed in the box, waiting for the judge to call their name.
Right.
You will be treated different. And having a lawyer looking out for you while you are on probation, especially in regards to violations, and most especially in regards to violations that you're able to deal with up front. In other words, let's say you don't have your community service hours done and you freaking know it. Whatever reason, you just didn't do them. You didn't get around to do them. You didn't have time to do them. Who knows? You were sick. You were in the hospital. You were lazy. Doesn't matter. Your lawyer will be able to come up with some explanation, however good or however bad, and bringing that to the judge before the probation officer brings it to the judge is a power play that you have. That's a pro tip. Let your lawyer get in front of the judge and get in front of the violation before it steamrolls you.
Let me give you what I believe is probably a scarier scenario. Suppose you're on probation and you went out that last night with your boys for a bachelor party and everybody went to whatever you want to do. I'm not going to stereotype. You guys all went out and you ended up doing some cocaine. And then the next day, your probation officer calls you and says, hey, I want you to come into the office. I want to drug test you. Don't run. Don't avoid it. Call your lawyer. I'm serious. You're laughing, but it is what happens.
I'm laughing. I'm only laughing because I haven't actually have another Haber really bad joke about that.
No,
when
don't.
You fail a urine test on probation, you know what happens?
No, I'm afraid to ask.
You're in trouble.
You're such an idiot. So, bad jokes aside, no, seriously, right? You call your lawyer, and your lawyer can call the probation officer and say, listen, I want to put this in front of the court right now before you violate it. He's going to admit. He's going to test positive. Let's go in front of the judge. Judge, my client has a problem. He's addicted or he's not addicted. He made a mistake. He screwed up, Judge. He got drunk and he took some coke and he's remorseful. You're so much better off doing that than letting them catch you anyway. Don't think you're smart. By the way, don't be using this whole, what are they, you know what I'm talking about, that they think is going to flush their system out. I don't know how many times I've had my clients tell me.
The cleansers.
Huh?
Cleansers.
I pissed because I took this cleanser. It was supposed to.
So, look.
Don't do that.
We're gonna get into our last segment on our final pro tips, but let me just say this. I don't disagree with what Ed said. If you're going down, again, it's better to go down proactively than reactively. Better for you to bring it to the judge than for your probation officer to bring you before the judge. But that said, I'm going to tell you right now, if you value your freedom, you need to not use when you're on probation. Absolutely. Period, paragraph. Because probation is a setup for failure, all right? If you can envision, and at the risk of using a bad pun, envision
you've already said two really shitty jokes. So
yeah, but this is not a shitty joke. This is not a shitty joke. This is a bad pun. And there's a big difference. You're basically being lynched, okay? You've got a noose put around your neck at sentencing, but there's a lot of loose rope. They've given you rope, and it is entirely your decision whether you live or you hang yourself, okay? So you need to look at probation from that standpoint. It is a setup for failure. Nobody wants you to fail, but if you do fail, you fail hard. And why? For the reasons I just told you. No right to bond. There's no speedy probation violation, okay? If you get arrested, absent COVID, because we still have some issues with that, but if you get arrested, you can file a written demand for speedy trial at any moment after your case is filed. That is your right. You can accelerate that case. That does not exist for a probation violation. You can sit in a jail cell for months on end waiting for a judge to get around to hearing your case. And by the way, they do that oftentimes. And part of the reason they do it is because it's the ability to extract a pint of blood, even if they decide to ultimately cut you loose. In other words, they still get a pint of blood no matter what happens. And secondarily, while you're sitting in that jail cell for 2, 3, 4, 5, 6 months, all of your cellies know that you're sitting in there rotting on a probation violation, which is a direct message to them. Don't violate probation because this is what happens. And judges know it and prosecutors know it.
Well, let me tell you something. As a former prosecutor, okay, if Michael was representing some guy that Michael has a pretty good case. The state's case is not that good. Obviously, I can speak for me personally. I've looked at the evidence. I am positive that Michael's client committed the crime. No doubt in my mind he committed the crime. I might even be able to prove it beyond a reasonable doubt, but as an ethical prosecutor, I have to ask myself, am I sure I can prove it beyond a reasonable doubt? But I know Michael's guy is a bad guy. He's got a long rap sheet, and he's definitely guilty of a serious crime. I would intentionally, I'm telling you what I did. I would intentionally offer a sweet probation deal. I might even say, Michael, you guys looking at 15-year min, man, but I'll tell you what I'll do. I'll give him an adjudication, 5 years probation, no special conditions.
Because you know that during the course of that 5 years, my guy's looking at 30.
But he's got to follow all the 15 rules that Michael just read out at the beginning of the show. And I'm telling you, I did it on purpose because here's the problem. Michael's client was looking at 30 years max with a 15-year minimum mandatory. I give him an adjudication or a withhold even, and 5 years probation. He violates his probation. If the judge finds that he violated his probation, the judge can sentence him to, Michael?
The max.
The max. So I can go right back and pull a Jen Psaki, circle back. I can circle back while on probation and get you for the 15-year min, man.
We call it
because you smoke pot.
We call it a slam dunk. We call it slam dunk.
It's a slam dunk. And you know why it's a slam dunk? I don't think a lot of people know what the standard is for the judge. Standard for a judge on your probation violation is that you did something that shocked the conscience of the court. So it's just getting arrested. Yeah, the state dropped the charges, but the judge says, yeah, but I'm shocked that you were on probation and you went to, I don't know.
You were hanging out with a bunch of knuckleheads. You were in
a place where there was drugs. That shocks me. Why were you at a rave party when you're on probation? And that's it. That's all it takes.
So there's two more subjects, but let's just hit the second to last one real quick, which is enforcement, modification, and early termination.
You know, the more we're talking about probation, as a guy who's got some expertise in this area, sounds a hell of a lot like a marriage.
So enforcement, modification, and early termination, all 100% discretionary with the judge. These things don't happen unless you ask. So again, a lot of these things you want to ask for right up front. Remember, right. If you can't afford to pay, you need to travel. Let's say you have a house. Let's say you have a vacation home in the mountains. And, you have to go up there every couple of months just to make sure everything's clean, deal with the property, whatever.
You'd like to go. Or you'd like to go. There's no restriction on your vacationing.
Just deal with it up front. Tell the judge, look, judge, I want permission to be able to go to North. Because otherwise you're going to wind up paying your lawyer to go to court and ask each time. Whenever you want a modification, let's say that you want a pass to be able to take your kids to Disney World for the weekend, or you want to go take a cruise. Got to go to the judge and ask permission. Because if you go without permission, guess what? Technical violation of probation. So
you definitely can't go without permission.
Some of these things you can deal with up front. Let's say, I have a buddy who goes to Disney. He's got young kids, and they're Disney freaks. They go to Disney at least once a month, sometimes more. And so if he had to be put on probation, I would say to the judge, look, judge, my client takes his kids to Disney once or twice a month. Please include that in his ability to travel while on probation. Because again, we know it's a recurring thing. And he doesn't want to have to pay me every time we go in front of the judge and ask for permission. That said, things will happen. Maybe you have an impromptu family gathering or a funeral or some special event or, whatever. I mean, look, I wouldn't recommend saying, if my client came to me and said, look, Mike, I want you to ask the judge if I can go to my buddy's bachelor party in Vegas, I would try and discourage him. Now, if he wants to pay me to do it, I'd still do it. But, I think it would be a foolish ask. On the flip side of the coin,
I would do it too, because I'd be getting paid to go and have a good time in court.
Exactly.
We're all going to be laughing.
Just for the comedy value alone. But the point being, all of these things are subject to the judge's personal mood, feelings, thoughts, biases, prejudices, good
Right.
mood, bad mood, had a good night's sleep, had an argument with her or his spouse, kids give him a tough time, whatever it is, traffic in the morning, couldn't get a parking spot.
Or look, Michael, why do they hire us? Why do you hire a lawyer that's been in the system and knows the judges in this county, so that when you're on probation, when I do this, I know you do it too. When the prosecutor offers probation, some of these judges in this county, and I love them dearly. I love some of these judges, but some of these judges, I'll look at my client and tell them, hey, do not screw up probation. This judge will launch you if you violate. I know how they are. Don't screw it up.
Which is why sometimes we will encourage a client, particularly somebody who's got history in the system, we will encourage them to take time over paper. And it's amazing, because the more savvy the client, the more they understand that. They don't want to be on probation either. If my client knows that he could do 364 clean or face 15 or 30 on a VOP because he's on paper for 2 or 3 years, he'll take his 364 and be done with the system.
And that's the other thing. So you understand, typically, at least when I was there, there's no bright line rule. There's nothing in writing. But there was usually, at least when I was in the state attorney's office, there was a consensus. The unwritten rule was, if you did jail, if you want, or there was a certain offer of jail, let's say the offer was 364 days, but you wanted probation instead, it would be 3 times as much, or vice versa. 3 years probation, you wanted to go to jail, we'd give you a third of the time to go in to do the incarceration, not house arrest, probation. You got 3 years probation. I don't want to do 3 years probation. Ed, my client doesn't want that. When I was a prosecutor, I'd say, okay, he can do a third of that in prison or jail. And so that's usually the rule of thumb. So if you think about it, usually taking a jail sentence also finishes your case a lot sooner. You're done. You go in, it's like ripping off a Band-Aid. Go into jail, stay in there, rip it off, and you're done. You don't have to worry about anything, at least unless you get rearrested.
The problem is most of our clients are first-time offenders, and they're not good candidates for jail. They just, they don't have the composition to do it. Let me get through the last thing, because we're running out of time here. But I want to talk about my last pro tip, which is something we just kind of touched on, which is recognizing that if you are on probation or community control or anything else, your probation officer is the boss of you. End of discussion. I guess, Ed, just like you said, maybe there's a lot of parallels with marriage. Well, maybe this is one of them. Your PO is the boss of you, no matter how.
You are his bitch. Kind of like if you're married and you want to stay married, sometimes, depending on your spouse, you might be her bitch.
So no matter what your PO says or does, no matter how sane or ridiculous, no matter how reasonable or irresponsible, no matter how bizarre or offensive or anything else under the sun, never, ever, ever argue with your PO.
Never. The
only words that should ever leave your lips.
Wait, Michael, there's one exception. There is none. That's the exception. There is no exception.
The only words that should ever leave your lips to your PO are yes, sir, no, sir, yes, ma'am, no, ma'am. And then here's the flip side to that coin. While your PO is the boss of you, the judge is the boss of your PO. So again, when you have a problem with your PO, whether it's in your mind or your PO's mind, take it to your lawyer and let your lawyer take it to the judge. If the PO is wrong, if the PO is off base, if the PO is out of his or her mind, the judge will straighten it out, period. Because the PO, just as you must listen to your PO or you get violated, the PO must listen to the judge, period. And they will.
And in fairness to the POs, Michael, I'm sure you've done this too. I've had my clients call and say, Ed, my PO doesn't want to increase my time for, let's say, for coming home or something that you think is the PO might be being unreasonable. I've called up many POs and been able to work it out with them directly. Never had to go to court. Just called them up, and it was usually either a misunderstanding or my client didn't explain it right or whatever. And many times I've talked to them, or sometimes there's been a compromise. Maybe my client explained it right, but the PO just didn't want to budge. But when I call and we sit down and talk, says, okay, you know what? Fine. I'll give him an extra hour to drive home. You're right. I get it. Traffic. And then I ask him to give it to me in writing in an email. And I don't bother the judge. If he ever does violate my client, I have proof that the probation officer told me, as his lawyer, that he was allowed to do these things.
Right. The other thing is that sometimes we can take it to the prosecutor too. Because if we get the prosecutor to agree with us, then we can submit an agreed order, and that agreed order will then direct probation as to X, Y, or Z, whatever it may be.
But don't fight with your PO.
Never. That is a fight you cannot win. Okay, because even if you win, you lose, because you could still wind up sitting in a jail cell for days, weeks, or even months just to be exonerated. And why? What good does that do you or your family?
And the reality is this: any judge that sees that you fought with the PO, even if you were right, because POs aren't crazy, they're not going to do something just out of control. They're not nuts. So generally, anything a PO prevents you from doing, or whatever the PO tells you to do, is kind of within the rules. So it's not going to be that drastic. And the first thing the judge is going to think is you're a troublemaker. That's why you're in this mess. That's why you got arrested. That's why you're on probation, because you're just a troublemaker. Why couldn't you have just called your lawyer so your lawyer could have handled it amicably? So the best rule is just, listen, it's not fair. I get it. It's not fair. But this is who you are. You've been labeled as somebody who's a problem. So you've got to try and change everybody's mind, and it's going to take a while.
Suck it up, Buttercup, right? Look, I'm getting a visitor from my
your cat?
The bug, yeah. So the last thing I want to leave you guys with in regards to probation are the two rules of probation. These are Haber's rules of probation, but they also happen to be general guidelines for life. And they're the same guidelines that I've been giving my now 16-year-old kid since he was old enough to comprehend speech. Because it really applies in virtually every facet. But targeted to what we're talking about today, here they are. Rule number 1, do what you are supposed to do when and how you are expected to do it. And rule number 2, don't do anything you're not supposed to do. It's really kind of that simple. It sounds simple.
Here's the question I have. Is your mother watching this show and thinking, yeah, why didn't you follow those rules when you were a kid?
Well, fortunately, I wasn't on probation. So, the difference is you can get in trouble with your friends, you can get in trouble with your spouse, you get in trouble with your family, but none of that lands your ass in a jail cell without bond, facing a reduced standard with admissible hearsay.
In some homes, it might land you under the stairs or in a closet, but that's a whole issue for another show.
Right, and not at your home, because that's where the Gimp lives. So, we can't take up his space. Anyhow, that's a wrap for today. I want to thank everybody for watching and paying attention. I hope that you guys learned a little bit about probation, and that you got some pro tips for those of you who are either on probation or maybe on probation. And hopefully we've given you armed you with information and knowledge that'll help you to survive it a little bit better. I want to thank you for paying attention. I want to thank you for joining us. I want to thank you for watching. And next week is episode number 20. And if all goes well, we have an interesting special guest lined up, and hopefully he'll show up. And I don't want to jinx it until I get confirmation. But either way, we will look forward to seeing you next week. On the 8th at 2 o'clock, where Ed and I will be back at your service. Thank you all very much for your time today. Ed, thank you for joining.
Absolutely. As always, had a good time.
We'll see you guys next week. Take care.